Hi, everybody. Today's Facts in 5 video is about divorce and estate planning. So you've done the work, you've put the plan in place, but then you subsequently get divorced. So what is the impact on your plan? And the simple answer is it's quite a big impact. So with your will, if you've named your spouse as a beneficiary to receive any assets, so whether it be real estate or money or just all of your assets, whatever it might be, instead of those assets passing to your spouse is automatically, or an ex-spouse, I should say, is now automatically going to be treated as if they had predeceased you. So for example, if your will says all to my spouse, and if my spouse has predeceased me, then to my children, that's exactly how your estate would function. You pass away, even if your ex-spouse is still living, the assets would be treated as, would pass to your children as if your now ex-spouse had predeceased you. Also important to note that if your now ex-spouse was named as a fiduciary under the will, so as executor or trustee under a trust, those appointments are automatically revoked because, again, the rule is that that ex-spouse is now going to be treated as if they predeceased you. So not only are they ineligible to receive the assets they would otherwise receive under the will, but they're also going to be ineligible to serve in those fiduciary roles. The will itself is not going to be revoked. The only thing that's going to happen is just that spouse is now going to be treated as if they had predeceased you. Similar effect for incapacity planning documents. So for that power of attorney, advanced medical directives, conservator designations, any kind of other fiduciary appointment or a document where you've appointed your spouse or now ex-spouse to serve for you in a fiduciary capacity, those appointments are revoked as well. That being said, I find it's a really good practice to still update these documents to avoid any potential confusion. And this goes for the will and the incapacity planning documents. It's always best following a divorce to update those documents to just remove the ex-spouse from those, so there's absolutely no confusion as to what they're entitled to receive or positions that they're entitled to hold and perform actions on your behalf. Because also keep in mind, if your ex-spouse has a copy of your power of attorney that says they are appointed, even if you have now divorced, that power of attorney is officially revoked. And even if you've signed a new power of attorney, but the ex-spouse still has that power of attorney in hand, they can still go into the bank or still talk to financial institutions and potentially use that power of attorney, just because the financial institutions they're dealing with have not been notified that that power of attorney has been revoked too. So not only should you sign new documents, you should take the additional step of initially trying to get copies of all of those prior documents from everybody you might have given them to, whether it be your ex-spouse or any financial institutions or your doctor's offices. Make sure you try to get copies of all those back, or at least have those people destroy the copies that they have. And if you've signed new copies, make sure they have the most up-to-date document. And also too, even if you don't necessarily have new documents in hand, just simply notifying anybody that may have a copy of those prior documents of the fact that you're divorced and those documents have now been revoked. So you don't need to always sign a new document to officially revoke those old ones. And again, by law, the spouse's appointment under those are revoked too. But again, the simplest course of action here is just to get rid of all of those prior documents to avoid any potential confusion. One thing to make note of is, even though under the will, the spouse is going to be automatically revoked as a beneficiary, or again, treated as if they predeceased you, this rule does not apply to beneficiary designations. So if your ex-spouse is still named as the primary beneficiary on your 401k and on your life insurance policy, and you don't update those and you pass away, those assets will still pass to your spouse. So in addition to updating your will and updating the powers of attorney and medical directives in those documents, it is also very important to be updating those beneficiary designations to name your current beneficiaries. Unless you do still want your spouse to receive some of those assets, or unless under a divorce decree, you're required to keep your ex-spouse as a beneficiary on those assets for a period of time, that's the exception. But generally speaking, if there's no rules permitting you from updating those beneficiary designations, you should absolutely do so to make sure that they reflect who your current beneficiaries are. So that is the Facts in 5 for today. If you have any more questions, please feel free to visit our website at www.kkc-law.com.